To get back to work. Again, we welcome our witnesses. Thank you for taking time out of your lives to add to our intelligence and knowledge about this topic. Mr. Bellissimo.
Mr. Chair and honourable members, thank you on behalf of the Canadian Bar Association Immigration Law Section for your invitation and the opportunity to comment on this very important study. The CBA is a national association of over 36,000 lawyers, law students, notaries, and academics. The CBA section has approximately 1,000 members practicing in all areas of immigration law. Our members deliver professional advice and representation to clients in Canada and abroad. A key aspect of the CBA's mandate is seeking improvements in the law and the administration of justice. The issues surrounding medical inadmissibility are large and international, but also personal and sensitive. The implications transcend many layers of our society. Attempting to forecast the demands on health and social services, not just monetarily, but in terms of the displacement of Canadians and permanent residents, is a difficult process for the families affected, as we've heard, and our many CBA members that represent applicants. As well, a medical inadmissibility finding has a serious consequence not only to the individual found to be inadmissible, but their other family members as well. Barring entry, and this ranges from family class applicants to workers and economic migrants, and it can hinder family reunification and have significant consequences on Canadian businesses. So to deliver a successful immigration program, historically there's been a need to protect public health and the integrity of the Canadian healthcare system while striking a balance with the legitimate needs of migrants in a manner consistent with Canadian charter values and international human rights standards. So with a view to maintaining the lawfulness and inclusiveness of the process, the penultimate question before this committee is where and how must that balance be struck? We've heard that the cost of healthcare in Canada continues to rise with advances in technology and our aging population. At the same time, an increasing number of migrants are arriving in Canada with both associated benefits and potential public health risk and health and social service costs. We've heard from many witnesses that the excessive demand, or ED regime, is not rationally connected to its purported goal of controlling healthcare costs and is discriminatory and should be repealed. This includes criticism over statistical methods used to determine the cost threshold and the factors considered in the ED assessment. Notwithstanding, we have come a long way since the Supreme Court of Canada decision in Hillowitz and De Jong nearly 13 years ago, and subsequent cases like Colaco, Sapru, and Lawrence, with certain CBA members led by the late Mr. Cecil Rotenberg QC, having worked for decades to minimize the discriminatory effects of medical inadmissibility. These efforts contributed to a much better process guided by the core teaching in Hillowitz that assessment should be fair, diligent, proactive, and with a move away from cookie-cutter methodology focusing on the medical condition rather than the individual. But there remain serious challenges that we have heard through testimony and have been highlighted in the briefs. I'll just address a few today. One, the presumptive categorical exclusion of applicants based on certain conditions remains a persistent and ongoing barrier for persons with disabilities, in particular in immigrating to Canada. Too many refusals are still based on improper or inadequate consideration of an applicant's individualized needs. Two, the bifurcate ED assessment process is undermined by a lack of proper instruction from IRCC to its officers, clearly delineating the distinct roles of medical and immigration officers. Medical officers should be assessing medical and non-medical factors, and immigration officers must determine only the reasonability of those findings. Three, applicants face obstacles in their ability to properly engage with officers when concerns are raised. The process and the language in fairness letters can be presumptive, unclear, and the transparency and accuracy of pricing uneven. This is also contrary to the court's instruction. The IRCC website offers little by way of meaningful assistance. So how can this improve? In March 2017, the CBA section commented on IRCC's review in 2015 of the existing model. A link to this more detailed submission can be found in our current submission. To list a few of those recommendations, we recommended the expansion of IRCC's Centralized Medical Accessibility Units role, CMAU, increasing the budget and personnel with a view to centralizing the process. To better align health and social services costs, in particular with respect to special education and prescription drugs, to mention two of the most common social services, and impact on waiting lists related to mortality and morbidity. CMAU should also update resources, including the IRCC website, the rewriting of procedural fairness letters in plain language with clear instructions, including an explanation of what can be privately dispersed. This would garner more effective exchanges, minimize the need for counsel, the intrusiveness of the process, reduce inaccurate findings, and streamline the M5 evaluation, which was listed in the IRCC's 2015 report as at 230 to 348 days. In addition, we recommended additional training for officers on the distinct roles of the decision-making of medical and immigration officers. Before this committee, we provided 12 additional recommendations, in particular the need for a detailed analysis of health and social service costs, as well as the impact on applicable waiting lists to support critical policy decisions moving forward. This would aid in 1, refining the admission threshold, 2, examine the impact and potential expansion of foreign national exemptions, quantified in the 2015 report as 27% of the 525,000 immigration medical assessments conducted annually, assessing a risk-based approach, modernization possibilities, and determining the feasibility of exploring other mitigating factors, including contribution to Canada by the applicant and their admissible family members. A view to the failed Australian attempt to implement a cost-benefit analysis could inform the feasibility of such an approach in Canada. This study would contribute to framing the balance that must be struck, as well as provide a more fulsome understanding of the need for further improvements, or ultimately, as many have suggested, repealment. Any findings, given the very serious issues at play, must be convincingly shown to exist. Following this study, the CBA further recommends that the figures and formulas for the setting of the excessive demand threshold must be transparent, with the opportunity for stakeholder input and comment, including information sharing with provinces and territories. So the CBA section, to conclude, supports IRCC's efforts to streamline the ED process while maintaining inclusiveness and individualized assessment. The process could be significantly improved if these recommendations were implemented without the need for a significant overhaul of the program or legislative and regulatory amendment at this time, pending further study. The evolution of the excessive demand regime since 2005 has resulted in a more equitable and effective process than before 2005, but should be further modernized, refined, and balanced to ensure medical assessments are consistently executed in accordance with Hillowitz, far removed from social handicapping and presumptive exclusions. Thank you.